Good afternoon. Today we will be discussing animal ownership law and considering the concerns, requirements, and themes regarding what the law says about owning an animal and its attendant benefits and obligations. My name is Geordie Duckler, and I will be your presenter today. I've been a trial attorney for over 35 years with licenses in Oregon and California, and I have been actively engaged in both plaintiff and defense side of civil and criminal litigation in every animal-related case of any type you might be able to imagine, all across the country, both state and federal courts. I've considered this specific topic about ownership in great detail throughout my career. I have written extensively on it. I presented several seminars on it. Today, I hope to get you well informed and up to speed about all you need to know in this fairly interesting area of law. We're going to focus on the common law in this area, but we'll also compare some codified rules and cases around the country in order to get the best handle we can on where all of those things fit into really what is a national conversation about animals. Now, ownership of personal properties is a very common arena in which animal-related legal disputes arise. The conveyance and control of animals, as well as the custody and the care which people are supposed to have for animals, these impact people both directly and indirectly in all walks of life. In their use and ownership, we know from the outset that animals are what are called, quote, tangible personal properties, i.e., physically movable objects capable of being possessed and conveyed to others. Property laws in general revolve around ideas of care, custody, and control, and of all sorts of objects, and those rules impose fairly distinct burdens and constrain very distinct freedoms on certain human behaviors. Now, in law, all property has to have some owner somewhere, either privately or through the state. Some properties have their own legal identities, and they accumulate explicit rules that adhere to their use, such as motor vehicles, while other properties are deemed to be merely the mechanisms, the infrastructure, or the superstructure that makes other properties interesting. They themselves have no special rules applicable to them, i.e., the component parts of a motor vehicle. We are going to find that animals occupy both spheres, properties with their own legal identities and properties that are simply collateral to ones that have legal identities. The division of property into real and personal creates a functionally significant test as to whether an object's value derives from being manipulated and, more importantly, easily manipulated. The benefit of being easily detachable from the land carries with it the detriment of having attainment and control made more difficult. Control also affects whether the personal property is natural or manufactured, the latter category being those things, such as products and goods, that have been intentionally modified by people from natural elements. A lump of clay is, in a sense, jurisprudentially distinct from a vase, solely because of what someone has done to the clay to make it into the vase. Manufactured personal property takes as its presumption that the manufacturing itself, that is, the human manipulation of the natural object, has been engaged in for some reasonable use, or consumption in some sense, for food perhaps, or for clothing, tool use, or aesthetic enjoyment. Now, as natural personal properties, animals are connected to those who, quote, manufacture them, which are also their owners, in unusual ways. Government ownership of animals relies on the concept of them being, quote, fera natura, a Latin phrase, objects in nature. As long as an animal remains wild, unconfined, and undomesticated, no individual property rights begin to exist in the animal, and it solely belongs to the state alone at the threshold.